Last month, I turned 45 and I had my annual health visit. Totally routine appointment, nothing unusual. But when I sat down with my physician, the first thing that she did before we even started was look at me and say, "Are you okay with me using an AI tool to transcribe our conversation today?" There was a small recorder on her computer screen. She explained that it would listen to our entire visit, generate a chart summary, and allow her to save a massive amount of time to do my entire chart note. I obviously said yes, but I loved that she asked. I love that she explained what it was. I love that she gave me the option. And that whole exchange took about 30 seconds. And it really showed me what responsible AI use looks like in a clinical setting. And it's been on my mind ever since then. Like, how can I apply this to spas? Hello, my dears. Welcome back to Spa Marketing Made Easy. I am your host, Daniela Warner, and today we are talking about AI compliance, data privacy, and what it actually looks like to use these tools responsibly inside of a spa or medical spa. Not in a scary, overwhelming way, more like me and you are friends having coffee, sitting across, talking about how fast these things are moving. And it's so important to get ahead of it now than to deal with it later. Okay, so here's what I want you to understand first. AI compliance, this is not a problem that's anybody has figured out yet. The law is moving slower than technology. Insurance is catching up in real time, and spa and med spa owners, well, you're really just kind of somewhere in the middle of that, trying to be compliant and trying to run your business at the same time. Now, I've been paying very close attention to AI in our space and compliance. I've been having a lot of conversations. I actually just wrote a pretty in-depth blog post that I'm going to link up below this episode. It's going to go much deeper into all of this. It also outlines some pretty incredible information that I learned after watching a webinar earlier last month. So I've got the link in the show notes to the blog and then also to that webinar if you want to watch it yourself. But for now, I want to just give you kind of a framework of what we are actually dealing with today. So there's two types of compliance concerns that I want to address. One is HIPAA, which specifically applies if you're a medical practice handling protected health information. And the other is a more broad question of AI governance, which applies to every spa, every practice, every business using AI tools in their daily operations. And you should really know about both. So if you run a med spa, injectable practice, any practice where clinical care is happening, HIPAA is a part of your life. You already know that, right? But the question that I keep hearing from spa owners is, does HIPAA mean that I can't use AI at all? And the short answer is no, it does not mean that. HIPAA protects what is called protected health information, PHI, individually identifiable information connected to someone's healthcare. So there's 18 identifiers that the government specifies, includes the obvious one, names, phone numbers, addresses, but they also include things like appointment dates, geographic data, and photographs. Photographs are so important because before and after photos where a patient's face is visible, that's PHI. Now, the practical test that I want you to start using before you involve AI in any task is this. Does this include information that could identify a specific patient? And does it connect to their health or their care? If yes, you're in PHI territory. If no, you're working with general business information and you can proceed with standard AI tools without that concern. Now, the misconception I see most often is people assuming that because they didn't mention a patient's diagnosis or condition, they're fine. That's not how HIPAA works, all right? If you type something like, "My patient, Sarah Johnson, has an appointment Thursday for a follow-up" into standard AI chat tool, you may have just created PHI because you combined an identifiable name with a health-adjacent appointment at a medical practice. The safer approach is to remove the identifier completely, all right? So say something like, help me write a follow-up message for a patient coming in for a tox touch-up. That prompt creates no PHI. Now, the standard consumer versions of AI tools like Claude and ChatGPT, they are not configured for HIPAA compliance. That doesn't mean that you can't use them. It means you should not use them to process protected health information without proper agreements and compliant configurations in place. Both Anthropic, which is Claude, and OpenAI have enterprise offerings that are designed for healthcare environments. Now, I would highly recommend that you talk to a healthcare attorney who's going to make sure that you are following compliance appropriately. This is money very well spent to have an attorney help you to understand compliance in this space. All right. Now, there's a part here when we're looking at kind of the broader governance that a lot of spa owners miss because they hear HIPAA and they assume it just doesn't apply to them if they're not in a medical practice. Now, even if you don't touch protected health information, AI governance still matters for your business because the risks are not only about HIPAA, they're about client trust, liability, intellectual property, and whether your insurance is actually going to cover you if something goes wrong. Okay, so I want to share 3 things that came out of that legal and insurance webinar that I watched last month. So first, your current malpractice or general liability policy may not cover AI-related incidents. So insurance carriers are actively updating how they think about this and how claims are happening. So before you assume that you're covered, review your policy and ask the questions directly. Second, the vendor is not the one who's liable. You are. A BAA or a business associate agreement gives a vendor its own obligations, but it does not transfer your compliance responsibility away from you. If something goes wrong with an AI-generated output that reaches a client, regulators and attorneys are going to come to you first. And third, AI governance documentation is becoming something insurance carriers are asking about at underwriting. Do you have a policy governing AI use? Do you have a review process? Can you show evidence of responsible practices? These are real questions. And if you can't answer them, that has implications for both your coverage and your exposure. So when I'm saying AI governance, what I actually mean is a small set of written documents that define how AI operates in your business, not a legal dissertation, not a 40-page compliance manual, a clear written set of policies that your team can follow and that you can show to a carrier or regulator if you ever need to. So we did this in our company last month. And here is what I would encourage you to think about building. So number 1, a client-facing AI disclosure document. All right. And this is the one I feel most strongly about. And it's one that most practices don't have. So I believe that your clients deserve to know if and how AI is being used in their experience with your business. Are you using AI to generate appointment confirmations, follow-up messages? Are tools being used to take any part of their consultation or intake process? This document doesn't have to be long. It should be in plain language, honest and specific, and having it builds trust because it signals that you are a practice that thinks about these things seriously. You should also have an AI policy covering privacy and intellectual property. Okay, so this is your team-facing document, and it defines what counts as confidential information in your business, client records, revenue data, proprietary protocols, staff information, and what can or cannot be entered into AI tools. It also covers your intellectual property. So if you've built service protocols or training systems or custom client experience sequences that are specific to your practice, that's your IP. This document is where you establish that it stays protected. Now, an approved tools policy, which is also really important. Okay, so what specific AI tools is your team authorized to use? What are they approved for? What are they explicitly not approved for? This matters because right now, without a written policy, every team member is making that call individually, often under pressure of a busy day. A simple approved tools list gives your team a clear yes or no without them having to think through implications every time. You also want to have an output review policy. All right, AI can make mistakes. It can say some crazy things. It can hallucinate details. It can produce something that is technically accurate, but doesn't sound like you at all. It can be off-brand or worse. Now, before any AI-generated content reaches a client, a human being with context should review it. Your output policy defines who does that at what stage and for what types of content. All right. It doesn't have to be burdensome. For a small practice, it might just mean that one person does a final read before anything goes out. The point is that AI does not get to be the last set of eyes on client-facing work. And then if you're a medical practice, you add on to all of this the specific documentation around what constitutes PHI in your practice, which tools are used in clinical workflows and under what agreements, and what your team does when they're unsure. That last one matters because when in doubt, don't is a reasonable baseline, but your team needs a clear path forward of what to do instead. Okay, so I know that this probably feels like a lot, but you don't have to build this all in 1 week, all right? Start with one paragraph, one AI policy in your practice right now. Put into it what information your team does not include in AI prompts. Something like, we do not include patient names, appointment dates, treatment histories, contact information, or before and after details tied to specific individuals in AI prompts. If you are unsure whether something is appropriate to include, do not include it. Ask first. Share that with your team. This is your starting point, and you can build the rest from there. Now, I want to point you back to the blog post on this very topic because it's going to go into a lot more detail on the depth and the legal and insurance side of things. There are expert perspectives in there from healthcare attorneys and insurance professionals that I think it's well worth the read. I want you to watch that webinar if you have a moment. Read through the blog. I've got them both linked up below this episode and also in the blog. But with all of that, that can give you a starting point of a conversation to have with your own healthcare attorney, knowing the questions to ask to make sure that you are compliant in this space. Okay, so here's what I keep coming back to. My physician asked that small 30-second question before my appointment told me that she was thinking about this. It told me that her practice had considered the tool, its implications, and what her patients deserve to know. That is a responsible way to use AI, and it's not complicated. Okay, so listen, AI is moving fast, and the spas and med spas that are most effectively using AI, they are years ahead, okay? Years ahead. They're the ones building responsible habits now with a clear understanding of what they're responsible for and why. These tools are not going anywhere, okay? And neither is the accountability that comes with them. So do it right from the beginning, all right? Put the policies in place, talk to your healthcare attorney, make sure that you're setting up your systems correctly. All right, read that blog post and let me know what you think. I'll see you next week.